I drive out
As if they did
back, and then I got a week to prepare to be gone for 29 days.
You would know.
Working.
Right, you know the one that's between this car.
And now with the tariffs, I can't buy them.
Oh,
Just gotta keep
have
doing
you
No, they're-
driven by? That
They're too expensive.
Too much
It's a
information.
hedge.
Just wondering if they did that. It looks,
Shaped, but
Okay,
it
so
changes
we are
colors.
recording, we got all the
It's
technical
a way
issues
to-
solved for tonight. We are gonna start our city council work session here in 5, 4, 3. Good evening, Cammy, welcome to the city council work session. This evening, we are doing a training, a state required training for electeds, and I think, is it mandatory for board members and committee members as well?
So this is not that training. This is your yearly ethics refresher plus a little bit of land use and a brief turnaround public meetings and records.
Perfect. So ethics, land use procedures, and public meeting law. So I think, Emily, you're going to take us through it.
Yes, and I will assume the position. Okay, so good evening, everyone, and everyone in the audience as well. I'm Emily Guymont. I serve as one of your city attorneys with Beery Elder and Hammond as the firm. I've got Josh Soper, one of the partners of the firm, online, and he's going to be covering the land use portion of this training that I am not qualified to do for you. So let's get it going. Sorry. Now it is. Okay, so a brief overview of what we're going to be talking about today. We're dividing this up into 5 sections. We're going to talk about briefly the form of government for cities, council authority as it pertains to the city of Canby. Josh is going to jump in and take you through some land use, and then I'm going to finish up with some ethics and then a little bit of public meetings and records. As I said previously, that new state requirement for public meetings training, this training is not going to satisfy that, but OGEC offers it, and Ashley Driscoll from our firm just had her training approved by OGEC, and that training is available on our firm's YouTube. You can watch their webinar recording and then meet your requirement that way too, if you haven't done so already. And I can send out that link again, Eileen, if you want to send it around. Okay, we're starting off with form of government. So what are cities in Oregon and how is it they can do what they do? It's kind of an interesting little civics lesson here. So, you know, our country has the federal constitution as its governing document, and the constitution does a number of things, but one of the things that it does important to us today is that it divides powers into powers possessed by the federal government and its 3 branches, and then everything else goes to the states, and that's your 10th Amendment right here. Anything that's not reserved for the federal government goes to the states. But there's no mentions of cities or counties or special districts or any other kind of political subdivisions of states, because that's what cities are. They're political subdivisions of states in the Constitution. So to the extent that before 1906, cities existed in Oregon, they only existed as an affirmative delegation of authority from the state itself. So if you were a citizen in the year 1900 and you wanted to incorporate a new city, you had to go to the Legislative Assembly and ask the Legislative Assembly to pass special legislation to incorporate a city. You couldn't do it yourself. It was utterly in the hands of the state government. Not only that, but the city that the Assembly created would only have the powers that the Assembly specifically gave to that city. So if the legislation did not give that particular city the power to have a police force, for example, then that's not something that that city could do. So it was very limited. It was very limited. It took quite a lot of process to get to incorporating a state. But then along came 1906, and the Oregon Constitution was amended with that language you see right there. In Article 9, Section 10, which took the ability to create new cities away from the state legislature and gave it to the voters. And then the authority that cities had after being created by the voters was established by the charter, which is part of what the voters would create when incorporating a city. So that's what we call it today. We call it home rule. You can do anything that your charter says that you can do, and subject to certain parts, so subject to the US Constitution, so nothing that the city of Canby can do can contradict the US Constitution. Same thing, so for example, like you couldn't say that here in the city of Canby, we will permit the quartering of soldiers in private homes without the consent of private homeowners, because the Third Amendment of the United States Constitution says that can't happen. Same thing for the Oregon Constitution, nothing can contradict the Oregon Constitution. And then we have federal and state laws that have a preemptive effect on local laws. So, for example, you can't create your own state land use goals. You have to follow the states because that's something that's governed by state law. And then there's federal and state sovereign rights that nothing that the city of Canby can do to abridge those, meaning you can't assess taxes against the federal government, and you can't use your eminent domain powers against property owned by the state or the federal government. But you still get to do a lot thanks to that 1906 amendment. First, I am happy to take questions as they pop up, or we can hold them to the end. We've got a healthy amount of time to get through all this. I'm not worried about stopping and starting for questions, so if you want to, jump in. Next part, council authority. Where does council's authority come from and what can council do? So your authority comes from two sources. The first being your legal authority, derived from state statutes on that topic, your charter, which is the city's governing document, as I just discussed, any ordinances that you enact that you are authorized to enact by your charter, and then policies that you create for yourself, such as your council rules and that sort of thing. But you need numbers in order to exercise that authority. So the rule is that you can only exercise that authority upon a majority vote from a quorum. So you are a council of 6 members plus a mayor who votes only in the event of a tie. And your charter says that a quorum is a majority of the council. So that would be 4 councilors is a quorum. So there's, yes?
If there's a vacancy or 2 on the council, does that strengthen the size of the quorum?
That's a great question. It's a little ambiguous. I know I've answered that for someone here. Was it you, Mayor, who emailed me previously?
I think so.
I don't want to misspeak right now, so I'll dig up that email and send it to you so you can take a look. But great question. If there's ever any question about whether something is in your scope of authority, the first place you want to check is your charter. See what's allowed and not allowed in your charter. Then go look at your ordinances and resolutions, check your policies, and if there still is a question mark, please reach out to assistance. Eileen is a resource, and then I and my firm are resources as well. And remember, the biggest part to remember here is that if any of you as individuals act outside of your authority as a member of council or act outside of council's authority, you will be personally liable for any consequences of that action. Meaning that the city's not gonna be able to step in and protect you from that liability. So if there's ever any question about whether something is appropriately in your scope, please reach out and we're always happy to help answer that question. I guess I'll pause there for questions before moving on. Seeing none. We're through the first 2. 3, we've got land use, and I'm gonna kick the mic over virtually to Josh. Josh, you tell me when you want slides to go.
Okay, great. Good evening, everyone. We can go ahead and go to the first slide. So as Emily said, my name is Josh Soper. I'm a partner at Beer, Elser & Hammond, and my specialty is land use. And so I'm going to be presenting this portion of the training for you this evening. Please, I'm not going to stick around for the rest of the training after the land use portion. So if you do have any questions about land use issues, please don't save them until the end. And also, we're going to cover a lot of different topics, as you can see from this agenda here. So it's probably best to ask your question while we're covering that topic, so we don't have to try to jump back around. Later on, it might be hard to keep track of all the different questions if we save them to the end, even though just this section. So I will start with a brief overview of some basics about land use in Oregon and kind of the roles of different agencies and where land use law comes from and why it exists. And then we'll cover a smorgasbord of important issues related to land use, wrapping up with some recent legislation. that you should be aware of. Next slide, please. So we've had land use law in Oregon for over 50 years now. It originated with Senate Bill 100 back in 1973. And at that time, kind of an interesting time in Oregon, politically speaking, where people from different parts of the state, different political alignments all came together over a shared concern about protecting some of the things that make Oregon special, the farm and forest lands. And also they saw things that they saw happening in California with regard to sprawl, and were wanting to make sure that that didn't happen here in Oregon. And so that's where Senate Bill 100 came in. And the purpose of the land use laws in Oregon is to try to achieve a variety of interests and goals that are sometimes complementary and sometimes competing. And those are livability, economic development, and protecting resources. And then just overall allowing for efficient and orderly uses of land. Next slide, please. So I'll talk a little bit about the role that the state plays and the role that cities play in Oregon's land use system. The state has enacted 19 statewide planning goals, which all cities have to follow, all counties as well. And then also enacts state statutes and administrative rules to implement those statutes. And recently, as we'll talk about a little bit during the course of this presentation, they seem to be enacting new statutes every legislative session. So there's a lot to keep up on. The agencies that you'll encounter at the state with regard to land use, bit of an alphabet soup. It's DLCD and LCDC, same letters in a different order to make it as difficult as possible for everybody to keep track of. But DLCD is the Department of Land Conservation and Development, and LCDC is the Land Conservation and Development Commission. LCDC is the commission appointed by the governor to oversee DLCD. And then the other one is LUBA, which stands for the Land Use Board of Appeals. So to back up a little bit, DLCD and LCDC, they are the primary agency concerned with all issues relating to land use in Oregon. LUBA is an independent agency that serves the purpose of hearing appeals of local land use decisions. Cities enact their land use vision through a comprehensive plan, which is the very high level goals, policy, and long-term vision for what the city is going to look like. And then that in turn is implemented through ordinances, generally referred to as a development code. And then the other role that cities play, other than that role of enacting those goals and the implementing regulations, is to then review development applications for compliance with those rules that the cities have previously set in place through their comprehensive plans and ordinances. Any questions on any of that? All right. So land use decisions that you will encounter can broadly be categorized into two types: legislative and quasi-judicial. We'll talk relatively briefly about legislative decisions, and then we'll have a lot more to say about quasi-judicial because there are a lot more rules that apply specifically to quasi-judicial decisions. But when you're thinking about these two types of decisions and trying to differentiate them and keep things straight and trying to understand why the rules are different, it can be helpful to think back to maybe a high school civics class where you learned about the three branches of government: the executive, the legislative, and the judicial, right? And so, as we all know, at the city level, those three branches, the idea of them being separated kind of falls apart. And city councilors, for example, exercise functions that would normally at the state or federal level be exercised by different people. And so when you're making a legislative decision, you're acting as a legislature would, a state legislature or Congress. And when you're making a quasi-judicial decision, you're acting in the way that a judge would. And so as we go to the next slide, we can see how that different conception plays out in terms of what the rules are. Next slide, please. So legislative decisions, as we think about what legislatures do and what Congress does, they involve the adoption of more generally applicable policies and standards that are going to apply in the future to a broad variety of people and variety of factual situations. And so some examples of those would include amending the comprehensive plan, zone changes that apply to a broad, large area of the city, and changes to the text of the development code. Because when you're making a legislative decision, it's the expression of city policy. The city, just like the legislature, is not required to reach a decision at all. Something can be tabled indefinitely, and you can decide just not to take it up. You could just decline to review something altogether. Somebody could bring a legislative proposal to you, staff could bring something to you, and you could say, you know, we don't want to deal with this now at all. Also, bias and ex parte contact requirements do not apply, which might seem a little strange, but if you think about how legislatures function, people are elected to the legislature specifically because of their biases, the ideas that they bring, their preconceived notions about how things should work and how things should function. And so you're allowed to bring those things to the table when you are making a legislative decision. And then also, for better or for worse, our legislature operates with a great deal of behind the scenes lobbying type activity. And for the same reason, you're allowed to engage in that type of activity when making a legislative land use decision. You're free to go out and talk to constituents and hear their thoughts and concerns and incorporate that into your decision making. And there's no disclosure requirement like there is for quasi-judicial decisions. Next slide. So quasi-judicial decisions, in contrast, because you're acting in the role of a judge, you will have those ex parte contact requirements that we'll talk about in a moment, and bias requirements, as well as some other requirements that are put in place for the same reason that we have those types of requirements for judges. We expect that when a judge is making a decision, they are a neutral, unbiased decision maker, and they're giving everybody a fair opportunity to be heard and a fair opportunity to make their case and influence the outcome of that decision. How do we differentiate a legislative decision from a quasi-judicial decision? Most of the time, it's pretty clear cut. Sometimes it can get a little difficult at some of the boundaries. The courts have set out a 3-part test and said that not any one of these answers the question definitively, but the more that one or the other is true, or each of those 3 is true, will counsel in favor of it being or not being a quasi-judicial decision. So an application that involves only a single property or a small group of properties is more likely to be considered a quasi-judicial decision. Conversely, if it's a lot of properties, it's likely to be a legislative decision. A decision that is based on pre-existing criteria is likely to be considered a quasi-judicial decision. And when the city is required to make a decision, that is likely to be constituted as a quasi-judicial decision. I want to focus on that first bullet point there because I talked about in the legislative slide zone changes. Zone changes are a great example of when this can get complicated. If you are doing, for example, a comprehensive look at the entire city and aligning zoning with your changes to your comprehensive plan, that is going to be a legislative decision. If an individual property owner asks you to change the zoning on their single property, that is going to be a quasi-judicial decision because of that first bullet point. When it's somewhere in between, that's when you talk to the city attorney. Next slide, please. So one of the most important things to understand in the context of a quasi-judicial decision. And one of the most difficult to wrap our heads around and deal with is the idea of bias. And so what the courts have said is that you're required as a quasi-judicial decision maker to make your decisions based on an independent review of the facts and law, and that you are not allowed to make your decision on any other basis, a positive or negative bias. And you're not allowed to prejudge the application. You have to consider the evidence that's put into the record and the applicable criteria, make the decision on that basis. What rises to the level of bias or doesn't quite rise to that level is always a difficult analysis. And so for this section of the presentation, I've found it helpful to include a number of examples from actual cases to illustrate where some of those lines are. Next slide, please. This first case that we'll talk about is out of the city of Depot Bay. And this is one where prior to making a decision, the city councilor sent a letter to the mayor and to the other councilors where they essentially reached a conclusion about what the outcome of the decision should be. They concluded that the applicant did not have the right to use the structure for the proposed use. That's a pretty easy one. Not surprisingly, LUBA found that that city councilor was biased because they had, there was evidence that they had formed an opinion before going through the land use hearing process where they would receive information that was supposed to form the basis of making that decision. They had prejudged the application. Next slide. This case out of Cottage Grove, city councilor signed a letter to the editor where they encouraged the project opponents to just leave town, and also requested police logs regarding the project's opponents and added them to the record of the proceeding. Again, probably not surprisingly, LUBA found that this city councilor was biased. But I think what's interesting here is particularly that second part, and this is what LUBA focused on, was the role of the city councilor is to consider the evidence that is put in the record by the parties to the proceeding, not to develop their own evidence and put that into the record. And developing their own evidence and putting it into the record indicates that they were stepping outside of their role of the neutral decision maker and acting more in an advocacy role. And that was a clear reason to find bias. This is a pretty egregious situation. I don't expect that any of you would ever request police logs about project opponents and try to add them to the record. But what I have seen increasingly in this era of Zoom meetings and all the information and knowledge of the world at our fingertips through the internet is city councilors, planning commissioners, doing their own research, sometimes live during the course of the hearing, and then sharing that information, putting that information into the record. I just didn't understand something that somebody said, so I Googled it and read an article, and here's what the article says about how much energy this type of facility would use or how much water they would use. Please don't do that. That is the type of thing that is going to cause an appeal suggesting that a city councilor was biased, and LUBA in many cases is going to find that somebody was in fact biased if they do that.
I have a quick question. This is Councilor Patton. For the planning commission, I know sometimes they'll be trying to get oriented with a particular site or whatever, and they'll bring up like Google Maps on their computer and bring up the subject property and see like what streets it's near or what other building it's near, just to get an idea of where it actually is at. Does that run afoul of what you're talking about, or would that be acceptable?
So I think that type of information gathering is, because it doesn't really counsel in favor or opposed to approving or denying an application, probably isn't going to establish bias, but it is going to be an issue as far as an ex parte contact, which we'll talk about later. So we need to make sure that that information is something that is in the record and that everybody has an opportunity to rebut that information and respond to it. And so for that reason, I discourage individual planning commissioners or city councilors from doing that, and instead would encourage that either staff do that on a screen during the course of the hearing so that everybody can see the same information and respond to it, or that staff produce maps based on Google Maps or whatever resources necessary, and put those into the record as part of a staff report.
Okay, thank you.
I have a question. I don't know how I raise my hand, you're on Zoom, but this is Councilor Stearns. So if I'm acting in a judicial role, can I, as a counselor, ask the parties for more information, like publicly, like I say, hey, I'm not clear about this, can you come back with a map, for example, or something else? Or is that something that I have to sit passively and only accept what's being thrown at me?
You can absolutely ask for more information. If it is the applicant's burden to provide enough information to convince the decision maker that all of the criteria for their approval are met. And so if you don't feel like you have enough information to make a determination about that it's absolutely appropriate to express that. And we'll talk later about open record periods or continuances. And that's typically a situation where a party would then say, can we have some additional time to get the information that you need in order to reach your decision?
I also have just one more question about the whole bias thing. So as a policy matter, I'll just give myself for an example. I don't want, marijuana stores in Canby. That's my biased opinion. I guess you could say I'm biased that way. But if somebody were to come up and say, I want to change it to the use for the marijuana distribution thing, can I just say, I'm biased against that and I vote no against it? Or I have to say, no, I can't be biased against it, I have to think of another reason to vote against it. I'm just, as a hypothetical, or maybe same thing with alcohol or something like that. If I have my own bias, I just don't like certain things, can I say that, or I have to shut up and just pretend like I try to pretend I don't have biases?
Great question, thank you. Yeah, that's a very important point. So the law recognizes that people have biases, that we're all human. We come to the table with some biases. You need to determine whether you are able to make a decision that is based solely on the facts on the record and the criteria. So if someone comes in and they want to establish a marijuana business, and they show that they meet all the criteria to establish a marijuana business under your development code, are you going to vote yes? If you are going to be able to make that decision based on the criteria and the facts in the record, then the law says that you are not biased and you can carry forward. If you're not going to be able to do that, then you have to recuse yourself from the proceeding. So you don't get to make the thing you definitely cannot do is make your decision based on your biases.
But then I could, if I wanted to, propose that the city have an outright ban on those things I'm biased against, and that's okay if it's a citywide thing. But if it's an individual case, I have to make it based on the law that exists. If I understand right.
Exactly. So in that first part, sorry, in that first part of your example, you're acting in a legislative capacity, so you're allowed to bring your biases to the table. When it's establishing what the laws are, you're allowed to bring your bias for or against marijuana businesses or any other type of business. That's perfectly acceptable. Once that law is set, then you're making a decision for an individual application based on what those laws are, then that's when your biases are not allowed to be part of the process.
Okay, thank you. That clears it up a little bit.
All right, we can go on to the next slide if there aren't any other questions yet. So this is a case out of the city of Jacksonville. And this one surprises a lot of people. This is a city councilor was a member of a church, and the church was the applicant in the land use decision that was in front of the city council. And the city councilor, LUBA found that city councilor was not biased. And the reason that they found that was because the city councilor acknowledged the circumstances that could cause someone to believe that they are biased, and then declared on the record at the opening of the proceeding that despite those circumstances, they believed that they were not biased and that they would be able to make a decision based on the facts and the law, and then conducted themselves throughout the course of that hearing in a way that showed that they did, in fact, make their decision based on the facts and the law. So this kind of relates to what we were just talking about on that previous slide in the question from the counselor. If there's now that you've said in a public meeting that you have a bias against marijuana businesses, somebody might have a reason to believe that you would not make that decision based on the facts and the law. And so the way to respond to that and deal with that is to acknowledge that circumstance at the beginning of the proceeding and make a commitment to making a decision based on the facts and the law, and then conduct yourself in a way that shows that you in fact do that, if you believe that you can. Of course, if you believe that you can't, then you need to recuse yourself. Same thing could apply if a city councilor had campaigned on a particular issue that relates to a land use decision, and any number of different things that could cause someone to suspect that you might be biased. That's the approach that you should take, is to own that situation and make that express commitment. The other point, though, that is important to understand here in this case is that the city councilor did that, and LUBA found that they were not biased, and that's great. But this case was still appealed to LUBA, challenging that city councilor's bias, that alleged bias. And as a result, that city incurred the expenses of defending that case at LUBA. And that could have been avoided if the city councilor said, you know what, I don't believe that I'm actually biased, but I recognize that there are enough circumstances that some people might believe that I am, and therefore I'm still going to recuse myself. If the city councilor had done that, then this wouldn't have even had to be a basis for an appeal to LUBA. So I think the first line of defense when there's reason to believe or allegations of bias is to consider whether you can just recuse yourself to take that issue completely off the table. If you're not going to do that, plan B is what we outlined here about acknowledging the circumstances and making that commitment. Go on to the next slide. This was one of my favorite cases when it came out in 2016 because I learned a new acronym and fun land use term. So we've probably all heard the term NIMBY, which stands for not in my backyard, somebody who's opposed to developments that happen in the proximity to usually where they live or where their business is. This city commissioner referred to project opponents as bananas, which is one step beyond NIMBY. Apparently, it stands for build absolutely nothing anywhere near anything. NIMBY would not want it near them, but they're okay with it somewhere else. Bananas don't want development to happen anywhere of any kind. Probably not a great idea to refer to project opponents as bananas or even NIMBYs. But LUBA said that did not rise to the level of demonstrating that a city commissioner was biased against the opponents. I think it's more of a criticism of the philosophy with which these people were approaching land use issues in their community, and not bias against those particular individuals or their arguments. Next slide, please. So we're going to move on to ex parte contacts, but before we do that, I want to ask if there are any other questions about bias. That's usually something that generates a lot of questions. All right, I don't see any. Ex parte contacts. So an ex parte contact, we call them contacts, but really it's broader than contacts. It's communication or information that is received outside of the record of a proceeding that is pending before the city. So as we were alluded to earlier, that would include site visits, Google Maps, that sort of thing. Any information that a decision maker has that was not part of the official record of the proceeding, either the hearing or the written submissions that are put into the record. And the important thing to understand here is that ex parte contacts are not unlawful. There's no law that says you cannot have an ex parte contact. What the law says is that if you do have an ex parte contact, you have to disclose that contact, and not just the fact that the contact occurred or that information came to you, but the substance of that information needs to be put onto the record in order to allow parties an opportunity to respond to it. So the idea here is that decision makers should, that everyone who's a party to a proceeding should know what information the decision makers have and have a full and fair opportunity to offer their own contrary information or argument relating to that information. And that's the reason why, even though ex parte contacts aren't unlawful, we strongly discourage people from having ex parte contacts as much as possible, because it can be extremely difficult, especially if you have a lot of them or lengthy ex parte contacts. It can be extremely difficult to meet that standard of disclosing the substance. It's not enough to say, you know, John Doe approached me at the grocery store about this application, or even opposed to this application. You need to say they were opposed to this application because they're concerned about the traffic impacts, because they see a lot of folks backed up at the left turn under existing conditions, et cetera. The substance of that communication, so that people can respond to that. The other point that I like to make here is a lot of times I get questions either at or just before a land use hearing, or sometimes during these trainings about, is this an ex parte contact? Is that an ex parte contact? When in doubt, disclose the ex parte contact. There is no downside to disclosing something that was not, in fact, legally constituting an ex parte contact. No downside to that whatsoever. The only risk to the city is if you fail to disclose something that does qualify as an ex parte contact. And that is what can invalidate the decision.
I have a question.
Go ahead.
Sorry to just interrupt, because when you define the party in the ex parte, so if it's just a concerned member of the public that says, hey, I really am opposed to this business or in favor of this business, but it's not a party, is that ex parte? Because people stop me on the street all the time and ask me to do things, and do I have to just remember and write down everybody who's asked me about something, or is it for just the people who are actually the parties that are presenting the land use change or whatever?
Great question. So ex parte is one of those Latin terms that lawyers like to use to sound smart. And it means outside the parties, literally. But what it means in a practical sense, because that's not a very helpful answer, is literally anything that happens outside of the official proceedings. So if it's not happening in the land use hearing itself, and it's not something that was submitted in the written record that staff provided to you for the hearing, then it's ex parte.
So basically you're saying, I do have to write down names of everybody that talks to me about a subject, that in the supermarket or wherever that meets, and say, yeah, so-and-so, I forgot his name, but he asked me as well, or I get that kind of thing if it's a controversial issue, or the citizens are not allowed to. Basically, what I'm hearing is the citizens are not allowed to express their opinions about it without onerous, disclosure requirements.
So I want to clarify that this only relates to land use matters that are pending before the city. So I'm not sure if in your example that was part of it. So if someone's just opposed to an existing business in town that doesn't have any land use applications pending before the city, that you're free to have those conversations. If there is a land use application pending before the city on something and someone wants to talk to you about it, my recommendation is to say, that's pending, an issue that's pending before the city. I can't talk to you about that not outside of the hearing. You should submit written comments or come to the hearing. That's the venue for you to be able to present information about that.
My understanding is the city council is like the appeal for the planning commission, but I don't keep track of what everything is in front of the planning commission, so I might not be aware that it's in front of the planning commission. I'm just trying to probe the what I need to be aware of, what I'm not. Somebody said I don't like that business coming in, and I just, since I don't pay much attention personally to what, you know, the planning commission meetings all the time, I might not even know that it's going to come back. Then I come up 3 weeks later, it's on the agenda. I'm like, oh, okay, I guess that's not what that guy was talking about. But you know what I'm saying? So I'm just wondering how aware do I need to be about all this to keep track of whether or not it might be appealed or might not.
Yeah, that's a great question about how to practically implement this. I mean, I think a few options are, some of which are more or less realistic than others. Keeping track of what is pending before the city so that you know. That's probably not always realistic, especially if you have a lot of land use activity. That's one option. Another one is to, as you said, write these things down so that you can disclose them if they do come before you. Third one is to try to ask those probing questions early on. You know, if somebody approaches you about something, ask, you know, is this something that there's a land use application for? Is somebody applying for a permit related to what your concern is? And then if not, then you can continue to have the conversation. And if so, then potentially no contact has occurred yet, or just a minimal contact that would be relatively easy to disclose.
Josh, this is Mayor Hodson. Maybe I think perhaps might help clear this up a little bit too, would be like in what issues or what potential land use legal matters would come up that ex parte contact could occur.
Right, so that is any quasi-judicial decision. So any decision that is not a legislative decision, that is a land use decision, where somebody is applying for, you know, a permit or a zone change or, you know, design review, any of those types of things, that your code allows for an appeal to city council regarding. Those are all situations where ex parte contacts could come into play.
Yeah, I can think of like some of the examples, Councilor Stearns, that we've had over the years, like anything from like, you know, yes, I've driven past the property, but I don't know that, you know, I don't know the property owners, or I know the location, or, you know, those have been kind of the major ones that have come up. I don't know, Jason, have you, what have been some of the ones you've had in years past?
Yeah, like they've driven by the site, they live, you know, within a certain mile radius, you know, they live near the site, so they drive by it, or those sort of things. I think the way I've interpreted it is that, let's say there was a developer that wanted to build a development on the property where this building sits. You know, if we're in the grocery store and someone comes up to us and says, oh my gosh, you know, that's ridiculous, they shouldn't be building houses there because there's already a building there and tear it down is horrible and da-da-da-da. You know, then eventually you say, look, I understand where you're coming from, but you know, this could be pending, you know, some sort of land use thing, and you know, I'm not able to really engage you in this conversation. There's nothing to stop them from telling you what they're feeling, but you just have to make it clear that, you know, you cannot act on anything that they're saying because there's this possibility. Is that a safe route?
Well, so yes, except that is then an ex parte contact that you will have to disclose. So you're going to want to make sure you take some notes about that conversation. And that's why my suggestion is typically to say, if as soon as you figure out that they are opposed to or supporting something that is the type of thing that we're talking about here, somebody who's trying to develop a site, for example, that you say the venue for you to be able to express your thoughts and concerns about that is through the land use hearing process. That's it's not an easy thing to say to a constituent. I understand that, and that's why it's not illegal for you to have that conversation as long as you take notes about it and disclose it. You don't have to say no to having the conversation or even listening to the information. But even just receiving their opinion is an ex parte contact and would have to be disclosed. So you can either plan to disclose it, or you can say, hey, if you want to express your thoughts about this, you really ought to go to the land use hearings or submit your written testimony.
Well, so herein lies the problem with this, and Don, correct me if I'm wrong. We have no clearinghouse for information as far as what land use things the planning department is working on. Like, there's no list that we have access to say that these are the 30 applications that are currently being processed through the public, through planning. So when we're at the grocery store, if we interact with 20 people over the course of a visit to the grocery store, I dare say it's a bit onerous for us to then carry around a notebook and record every single name that we've talked to about any one piece of property in the city to then find out several months later that they're gonna build a house on that property. I would have to believe that there has to be some sort of reasonable expectation of what we as volunteer politicians are able to do. And as long as we like curtail the conversation and don't get involved with the situation, we don't have to keep like copious notes about every single person we talk to over the course of a 3-year period, because sometimes these things take years. Whereas if it's found out that you've been like having multiple conversations with some of the community about a piece of property next to their house because they don't want it to be developed, that I think is a completely different story. Is that wrong?
Maybe
So, go ahead, you go, and I got a few things to say to that.
just maybe to not make this, it's not the entire world, I don't think, of possibilities, and so maybe I'll narrow that down a bit. I believe in the state, what we're gonna get to, Josh, in his presentation of Senate Bill 1587, which actually has narrowed this even further. So it's those items that have the potential to reach the council on appeal, and that list is rather short right now, because of the state actions that just happened. Those would be variances, conditional use permits, planning unit developments, and rezones. And everything else essentially doesn't necessarily have those opportunities to reach the council, and you all are not aware of these things because we don't really talk to you about these things. They're planning commission items. Typically, the other items now, under the state changes in the regulations, will be appealed to the planning commission. Those will be, now that's the step. That doesn't really solve it, and maybe there is an opportunity for us to, I'm not sure what that looks like, but we do have those posted on the website, just like the council, but we would be fine with sending something out if that's helpful, but I don't think it's the entire world of possible scenarios where, but you all don't know what those are, to your point. And so I think it's really those things that can reach you all in that situation on appeal. And then you all have that ability to remand it back to the planning commission based on the code as well, which is traditionally what's happened, at least the last 4 years. There has not been any action by the council on appeals. Is there new information? Is there new information? That's usually the question. If there's new information, they want the planning commission to re-review that was.
Yep.
So that doesn't necessarily excuse that, but maybe it helps put some boundaries on it, which I get the fact, you're in the grocery store, you have no idea what's going on. And like, I think the parameters of this is much more narrow than like, I think what you all are thinking. Hopefully that helps.
No, that's kind of what I was getting at, is I understand that there is the letter of the law, and that, you know, we all try to act in good faith with those laws. But in the course of a day, when this is not our full-time job, you know, there are going to be times where we maybe slip up. And I would hope that, you know, the fear of not keeping every name of every single person we talk to over the course of a year about any particular piece of land in the city doesn't curtail us from doing our job. And, you know, I've watched planning commission meetings, they don't follow the rules all the time when they do their stuff. But but when it comes down to it, they're doing it pretty close, and they go through the process. And so I just, you know, I know that sometimes we can get hung up on the black and white, but oftentimes there's a little bit of gray as well. And I think in this scenario, there might be some of that.
I just wanted to add in, Dawn, I mean, you know, the planning commission has acted and that there's a period of time that, you know, that the appeal has to be filed. So it seems to me that there's a moment that you could say to the council, heads up, this is going to be appeal, you're going to be functioning in a quasi-judicial capacity on this land use matter, which really helps kind of narrow the scope of what you are having to keep in your mind.
No, but I disagree, because what we just heard was that as soon as that application hits planning department's desk, it is now officially received by the city. And so technically, if one of my neighbors is going to do a land use thing with their property, and someone starts talking to me about it, and that application is in here, and then eventually it makes its way to us as appeal, technically, they could go all the way back to that conversation I had after it hit planning department's desk.
And I
So
would,
it's not just based on when the planning commission has seen it, it's based on when it lands in our planning department. Am I wrong?
I think you're correct, but maybe again, try to put some parameters on this is that like what Josh is, and I'm not speaking for him, but what he's saying, I think, is it's best not to engage in the land use discussions, you know, if there's a pending application period, would be the safe route. We'd be happy in the planning department to send out anything that would be of use for the council, but generally speaking, it would be good just to avoid those discussions, because if it does have the potential to reach you all, you would have to reveal it and then possibly recuse yourself if you felt you were biased on that. And maybe that's the best answer to that, is just to say, you know, I don't want to be in a position where I claim to be biased later on. If this does come to me, then I can make my informed decision based on it being a council member.
Okay.
But you're saying that only the trigger happens when it hits the desk of the city. So for example, I could talk all day long about, you know, 4th and 1st Street, how it should be something else. But then the minute that the application for a change comes up, then I have to shut up at that point.
You have to be quiet.
Okay. And the other thing is that I'm just curious as the council, there's most things probably happen and no one cares about, but there's some things in the city, before I went on the council as a citizen, that everybody talked about, like where we're sitting right now. That was talked about everywhere. And you know, the beer library and other kinds of people talk about it all the time. And so when there's a controversial issue in the city, it's like you can't just go like this and pretend like you can't hear it. And I don't think that'd be a service to the citizens either, you know. But I don't know, I just bring out that seems to be
No, and I don't think,
a difficult ask. I could say, yes, everybody's talked to me about this, and for the last 4 years.
Yeah, but I think what Josh is saying here is something like that. That was more of a matter of opinions on it. We weren't doing a land use, you know, hearing on, you know, the beer library. That was just, you know, so it all depends on, I think, those 4 or 5 things that Don just rattled off that create that opportunity for us to be, you know, having to say, okay, I really can't talk about that right now, because, you know, and that's, I mean, even back in the day when I was first on the council, our city attorney at the time, because I was the liaison of the planning commission, said, don't go to the planning commission meetings. Like, stay for like the first 5 minutes of introductions or whatever, and then leave, because there's a chance that you would hear something at a planning commission meeting that might not end up in, or end up in front of the city council. Because it deals with land use and property, right, all those things, so, yeah, I don't think of it as just a general, like, no, I don't want, something to happen to the old water tower on Fourth Street. That's not, I don't think that's an ex parte, contact, that's just, I think, citizen input to you as you're walking down the street, to work, so.
Well, to that point, I wanna double check this, because I had a similar question when I became the liaison to the planning commission. And the way it was explained to me is that going to those meetings and watching those meetings is not a problem. Because essentially, whatever decision they make and whatever conversation they make, essentially gets folded into the record of that thing and then comes up to us. So it's not, I would not be, as long as I'm not influencing it at the planning commission, whatever comes up to this council is essentially part of the record. I just happen to know about it real time compared to other counselors. Is that correct? Or am I not supposed to be paying attention to what the planning commission is doing and just?
I'll defer to the legal counsel on that item. I did want to.
They're all on YouTube, we can watch them.
Yeah, I mean, I'd like their advice on that. I did want to share something though on the legislative branch, which the council is just to focus a bit on that and as what you can do, which is obviously legislative items, comprehensive plan, transportation system plan, urban growth boundary, those are fair game. Those are not individual projects. And so I'll let Emily and Josh speak to the advice on going to planning commission meetings. I really don't know how to advise on that, but I think that there are very few applications that generally get appealed, but I would say that it's best, again, to stay like away from that process. It would be my recommendation, is to not over immerse yourself, because you have to reveal that. And that somebody could claim on the council that you've been biased, depending on what that topic is. One of the other council members could say that. So I'll let Josh and Emily speak to that.
Great. That was a great discussion. A few different things to respond to there. I think, yes, it's the trigger, confirm the trigger is when an application is submitted to the city. So when it lands on the planning department's desk. I think Don makes a great point that the practical effect of this is limited by the fact that very few of these actually end up reaching the city council. So that helps. Part of it is I understand it's difficult, particularly in a community where people are coming up to you because they recognize that you're city councilor and they want to talk to you about city issues. But it's a mindset shift of, if somebody wants to talk to me about a development, a specific development application, that is not something that they should be talking to me about in this setting. Similarly, if somebody had a concern about, some criminal complaint that they had about somebody, you would say, you need to go talk to the police department about that. I'm not the person that you call when you have a concern about a criminal activity situation. When somebody's talking to you about a specific development that they're concerned about, that is an opportunity to channel them into the appropriate venue for raising those concerns. So that's that. On the attending planning commission hearings, generally, yes, it's true that everything that happens at that planning commission hearing is going to become a part of the record, and that is going to then be in front of the city council if the appeal does go to city council. And so it's not an ex parte contact concern to observe that. Where ex parte contact concerns could happen would be what happens before and after the hearing, right? Where somebody wants to talk to you about what just happened.
Yep.
or what's about to happen. That's the kind of conversation that you want to be sure to avoid.
Okay.
All right. Is that enough on next Friday contact? Should we move on to the next slide?
Yes, sir.
All right. Conflicts of interest. So I'm gonna talk very briefly about some ethics issues. And in fact, I'm gonna probably skip a couple of slides here because I usually give this as a standalone presentation, and Emily's gonna be talking in more depth about ethics law issues. But I do want to point out that conflicts of interest although that is an ethical obligation under ethics law, which is distinct from your obligations as a quasi-judicial decision maker under land use law, there's often a great deal of overlap between conflicts of interest and bias. And so when you're faced with a situation where you think you might have one or the other, I want that to be a flag in your mind that you could have both. And the implications for that are that bias, if you violate the rules relating to bias, that can result in an appeal to LUBA and the city incurring expenses related to that, but not any personal liability. If you violate the rules relating to conflict of interest, that can result in personal liability. And so you need to be thinking about it from both of those angles. And if you think that you might have a conflict of interest situation, as I'm sure Emily will tell you later, when in doubt, call the Government Ethics Commission and get individualized fact-specific guidance from them to address that. Next slide, please.
I have a question, and this goes back to ex parte, but also, I'm personally in my side job, well, actually, this is my side job, but my real job is I'm an accountant, and I know a lot of people's financial information that are residents of Canby, of a lot more detail, but I am not ethically able to disclose that information, obviously. But then what does that do if one of my clients were to come before the me, you know what I'm saying? So how do you, and you probably understand as an attorney, there's privilege, and then if you want to say you were on a council and then you had, how do you navigate that particular issue where you basically can't disclose what you can't, what you know, what you don't know, but you're required to disclose. So basically a conflict between two laws, basically.
Right. So a lot of different, that's a great, I should use that as one of my examples in this presentation. That's a great one that triggers a lot of different possible issues. So that could lead to an allegation of bias, right? Are your dealings with this person or your knowledge of their finances going to influence your decision in a way that is not based on the facts and the criteria that are part of the record in front of you? That could be a bias situation there. Is it a conflict of interest? Is your decision in this case going to influence you and your own personal finances or the finances of your family or business, which it could, depending on the particulars of the situation? And do you have information that could factor into your decision-making that is not part of the record? All of those would lead me personally in that situation to consider recusing myself, depending on the specifics of the situation. It's a little hard to
I can recuse myself without saying why. Is that I can recuse myself without saying why? I just say I wish to recuse myself and just smile.
And smile. It's
Right.
recommended.
And leave, I guess, in the room. Okay.
Great, I think we're on the next slide here. And this one, I'm gonna just gloss over because again, Emily will cover this in more detail for you. The one thing I do wanna highlight though, is that when she talks about the gift clause later on, and she's gonna talk about people who have a legislative or administrative interest in your decisions, a textbook example of the people that you have to be worried about giving you gifts because they meet that standard would be somebody who has a development application that could come before you for a decision. Next slide, please. again, we'll gloss over this one. This is, I think, the last one that kind of duplicates with some of Emily's slides, except to note that public meetings law issues can often come up in the context of controversial, high interest level development applications where there is a lot of discussion about that application on social media. And so be careful in engaging in any of that conversation, both as an ex parte contact and a potential indicator of bias, but also because if a quorum of city councilors end up being involved in that discussion or seeing that discussion, you could end up with a public meetings law violation as well. Next slide, please. All right, so we talked about bias, ex parte contacts, conflicts of interest. There are a couple other things I want to talk about specific to the requirements for what has to be part of a hearing, for a quasi-judicial hearing, which are all geared towards the goal of making sure that these hearings provide everybody with a full and fair opportunity to participate. So of course there are, just like there are for public meetings, there are requirements about about notice that has to be provided. It's more onerous notice requirements than for a regular public meeting. You often have to provide individualized notice to nearby property owners. Staff will typically provide a script to open up the hearing, which will meet certain other legal requirements, such as identifying the criteria and noticing everybody that there is a raise it or waive it law, which essentially says that if you don't raise an issue at this hearing, you're not able to appeal on that basis. At the initial evidentiary hearing, which is the first hearing where evidence is taken on a land use application, anyone can ask for time to present additional arguments or evidence, and that request has to be granted either by holding an open record period or continuing the hearing. I do think it's, and Don can correct me if I'm wrong here, it's going to be a rare circumstance, if any, where the initial evidentiary hearing is before city council. Typically, it's going to be something where there was a planning commission hearing first and then it's being appealed to city council. So that rule wouldn't often apply to you, but just something to be aware of. And then also for that, to be aware that the applicant gets 7 days after the record is closed to submit final written argument, but the applicant can waive that period, and they often do. And that's just for the practical reason that applicants, time is money. They usually want to get their decision as soon as possible. And if they don't feel like they need that extra 7 days to make that final written argument, then they're going to waive that. We can go on to the next slide if there aren't any questions. So this comes up outside of the land use context as well, but often does come up in the land use world. And so I want to talk about this a little bit here briefly, which is that the presiding officer, which is going to be the chair of the planning commission or the mayor, depending on who the hearings body is, has the inherent authority to maintain order and decorum in public meetings and in hearings, which includes establishing reasonable rules for the conduct of the meeting, to the extent that those rules aren't already established by council rules or some other policy document. And again, to the extent it's not already established by another city policy or regulation, that also includes the order and length of public testimony. Less pleasantly, the presiding officer also has the power and duty of dealing with disturbances during public meetings and hearings. And the recommended process for dealing with that, and to be clear, this is when someone is disrupting the ability to conduct city business and conduct the hearing, not just somebody who's saying something that you disagree with or find unpleasant, but it's not the person who is saying things you don't like during their allotted time to speak. It's the person who's shouting from the back of the room, clapping, booing, that sort of thing. is to provide a warning about that conduct is not acceptable, you're disrupting the meeting. If you don't stop engaging in that conduct, we're going to ask you to leave the meeting. If that behavior then continues, you can, as you warned them, you would ask them to leave the meeting. And if they don't leave the meeting at that point, they can be treated as a trespasser under Oregon law, and you can, if necessary, contact law enforcement and have them physically removed from the meeting. My practical recommendation in all of this is to use recesses liberally. So they can be an effective tool at the outset of a situation like this. If people are being disruptive, provide that warning, call a recess to allow people to cool down a little bit and then get back to the meeting. But in particular, if you need to have somebody physically removed from a meeting, or if they won't stop disrupting, using a recess is a really good idea. I've seen it happen before. You really don't want to try to be conducting business while a police officer is escorting somebody out of the building.
Yeah.
Next slide. Was that a question there?
No, I say just keep going.
Okay.
It'll get sorted out in the end.
Okay. Next slide. All right. Criteria and findings. So we've talked already about how when you're making a quasi-judicial decision, the expectation is that you are making your decision based on the facts that are put in the record and applying those to the applicable criteria. What that means is that your approval or denial have to be based on specific standards and criteria that have been adopted by ordinance to apply to that type of decision. The decision then must be accompanied by findings, which is a written statement that explains what the city believes the relevant criteria are, what facts were relied on, and how those facts connect to the criteria to show that they were or were not met. They have to be based on substantial evidence in the record. We can talk a little bit more about that in a moment. And they have to resolve conflicts in the evidence. So if there are, there's different testimony that contradicts each other about facts, then the decision maker needs to decide which facts or which evidence or which person who's providing that evidence they find to be credible and explain that in the findings. The good news is that staff will write the findings for you. So you generally don't have to worry too much about this, other than that if you want to make a decision that is different than what staff drafted their findings about, then staff will have to modify the findings accordingly. And the other thing that you want to make sure is that you're giving staff the information that they need to make those findings. So if you are finding that one piece of evidence is more credible than another, saying that so that staff can know what to put into the findings. And the other suggestion here is, to the extent practical or to the extent feasible, I know this can be practically difficult, to limit your discussion during a hearing to the criteria and evidence. So I will go so far as to say that I don't know that I've ever attended a land use hearing where the public attended as well and provided testimony, where there was not public testimony that was irrelevant to the criteria for the application. That is the norm. And particularly when there is a lot of that type of testimony, it can be very difficult to not respond to that testimony. You'll often hear people, for example, concerned about the effect that this development is going to have on their property values. That's never a approval criteria that I've ever seen. And so that's not something that you can base your decision on. And it can be difficult to not engage in some discussion at the city council level about something like that is raised by a lot of people at the hearing. Because you want to be responsive to the concerns that your constituents are raising. But engaging in too much conversation about that sort of thing can suggest that that was, in fact, the basis for your decision, and that the other things that are cited in the findings were pretextual. And so to the extent that you can, my recommendation is to avoid that. And one way to do that is to say, we've heard a lot of concerns about X issue. You know, we hear and appreciate you bringing those concerns to us, but we, in this capacity, quasi-judicial hearing, we have to make our decisions based on this limited set of criteria, and we're not able to consider that. I want to talk a little bit also about substantial evidence in the record. Substantial evidence means, the courts have explained, substantial evidence means information and evidence on which a reasonable person would rely, which is not very helpful, unfortunately. But what that means on a practical level is that there is going to be a significant burden to overcome evidence that is submitted based on expert reports. So what we often see in land use hearings is a traffic engineer conducts a traffic study and submits a report about the traffic impacts of a development. And then you have a bunch of testimony from neighbors or other concerned citizens disagreeing with that traffic study. It is not impossible to, in some circumstances, have non-traffic engineer testimony be sufficient to overcome a traffic study, but it's a pretty high bar. They're going to have to be more than just, I disagree with that. It's going to have to be pointing out flaws, perhaps, in the assumptions that that study was based on. And so that's just something, I guess, to flag and keep in mind, is that there are certain types of evidence that are generally going to be considered by LUBA and the courts to be inherently more persuasive and credible and more substantial, and to be mindful of that when you're considering that type of evidence and testimony.
Should we use the federal rules of evidence or something, and or we can't strike things from the record, can't say, hey, that's hearsay, or we have to just say, take it all and just individually say, well, that's hearsay, but there's an exception to that, or for example, your expert, can we ask them who's paying the expert, you know, look for bias on the expert, that sort of thing, or I don't know. It just very much reminds me of a court hearing, so I'm just thinking, just rules of evidence.
So the good news is that you do not have to. The law does at least recognize that you are not judges for purposes of applying the federal rules of evidence. That's why it's this concept of what would a reasonable person rely on in the conduct of their ordinary affairs, right? Is this the type of thing that a reasonable person would consider to make more or less likely that something is true? Because that's what we're dealing with evidence. We're not. Is this fact true or not, and is there reason to believe that this evidence supports it being true or not? It does not have to be anything nearly as formal as federal rules of evidence.
I didn't think so, that comes to mind. I didn't think so, but that just comes to mind when you're all saying the evidentiary things. I'm like, okay, just do an evidentiary hearing first, figure out what to do.
All right, next slide. So let's talk a little bit about appeals. Don's comments earlier covered a little bit of this, but just to make sure we don't miss anything here. So typically, cities' development codes will divide applications into different categories, type 1, type 2, et cetera, which that categorization then defines who is the initial decision maker and then where appeals will go. And then code will also frequently explain what the nature of that appeal would be. And there are two general options under land use law. There's de novo, which is a completely new hearing process, or an on the record hearing, which is a hearing where, so for example, a planning commission decision is appealed to city council. City council would not take any new evidence. They would base their decision only on the evidence that was entered at the planning commission. Beyond the local appeals, that's when appeals will go to LUBA. And then from LUBA, they enter into the Oregon court system, beginning with the Oregon Court of Appeals. In one of my earlier slides, I had flagged when we were talking about ex parte contacts. I think I forgot to address this at the time because we had such a robust discussion about ex parte contacts. Is that the time period during which the ex parte contact rules apply starts when the application is submitted. We talked about that part. It ends when the final decision has been made. But keep in mind that decisions can be appealed and then remanded back and come back to you. So if the city council is making a decision on something and it's gotten to the level of city council, there's a pretty reasonable chance that it might go beyond that and go to LUBA. And so you need to continue to follow the ex parte contact rules even after you made your decision until either the appeal period to LUBA has expired and you know it's not going to get appealed, or if it does get appealed to LUBA, continue to follow those rules until that appeal process reaches its final conclusion, because there's a chance that you may be making another decision on that same application. And frankly, LUBA's favorite thing to do is remand decisions back to cities and counties. And so if something gets appealed to LUBA, majority of the time, you're going to be doing it again. Next slide, please. So you may have heard the term 120-day rule. This is a statute that requires that all the final decision of local government, including all local appeals, must be made within 120 days after the application is deemed complete. That sounds like a lot of time, but when you take into consideration the notices that have to be provided, the staff review that has to be conducted, and potentially multiple hearings, especially if there's a local appeal option, it can get tight sometimes. There are two consequences if the city fails to meet that deadline. The first and the most the one that's actually triggered the most in reality is that it requires the city to refund at least 50% of the fees or deposits that the applicant made, or the unexpended portion, whichever is greater. The other is that it allows the applicant to file a writ of mandamus in circuit court, which essentially transfers the land use hearing process to circuit court, and the court will approve the application unless the city can show that the approval would violate its code. That sounds like that would be a pretty impactful consequence. The practical reality is that applicants rarely utilize that, especially if it's just a relatively minor, extension beyond going beyond the 120 days to make that final decision, just because of the time and expense involved in pursuing that proceeding in circuit court. The 120 days set by statute can be extended by the applicant in writing by up to 245 additional days, which if you add it with 120 gets you 365 days, 1 year. Or if the parties are in mediation, it can be extended up to 335 additional days. I emphasized on there that extension must be in writing. And my practical suggestion here was to have blank forms available at a hearing to allow an applicant to make that request in writing at the hearing before the city acts on that. It doesn't happen very often, but I have seen situations where an applicant verbally agrees during a hearing, city continues the hearing or takes other action based on that, relying on that, and then they have a change of heart afterwards. So best to get it in writing before acting on it. And then just a brief note here that there is some legislation in 2024 that allows cities an additional 7 days to reduce their decision to writing beyond that 120 days. It applies very narrowly. And so it just kind of, I guess I had that here in the interest of completeness, but it's unlikely to come up. Next slide, please. Another rule of land use that you may have heard of before is we call it the fixed goalpost rule, colloquially. this is the rule that says that the decision must be based on the standards and criteria that were applicable at the time the application was first submitted. So what that means is when an applicant submits their application to the city, they lock in the code, comprehensive plan, etc., that are in effect on that date, and that's all that the city can apply throughout the entire consideration of that application, including if it's appealed to LUBA and remanded. I've seen situations where the city has amended their code many times since, and they're applying a code many years old and outdated at that point because something has went through that whole 120-day process, and then appeals and remands and appeals and further appeals. So they lock that in at the time that they submit their application. And developers will sometimes use that strategically. If they see that a city is considering a change to its development code that is not favorable to something that they want to do, they'll submit their application to get it in under the wire and lock in the existing code. There was a change in the 2024 legislature to modify this requirement to allow specifically housing developers to opt in on their own choice voluntarily, opt into standards and criteria that go into effect after their application was submitted. A lot of cities were doing that already, but this makes it a requirement. And it means that the law also provides that if they do choose to opt into the new regulations, then the process of staff reviewing to determine that it's complete and that 120-day clock will start over. So it's almost as if they've submitted a new application. They just don't have to start over as far as application fees, that sort of thing. Next slide, please. Clear and objective code requirements. This is another thing that you may have encountered before. This is a requirement in state law that says that all standards, conditions, and procedures that regulate the development of housing must be clear and objective. What that means is that if you have regulations, conditions, procedures for the development of housing that are not clear and objective, they have to be treated as if they do not exist. They cannot be applied to an application. So you'll often hear housing developers arguing that certain criteria are not clear and objective, and that you therefore can't apply them to their application. The city does not have to only offer clear and objective criteria. As long as you have a way for developers to seek approval of their development based on clear and objective criteria, you can also offer an optional other path that involves discretionary criteria and discretionary decision-making, as long as that clear and objective path remains available to the developer. This is something that sounds very simple in concept and is extremely challenging, if not impossible, to fully accomplish in reality. Cities across Oregon have made varying degrees of efforts to make their code clear and objective. Some have done a very good job. I don't know, though, that any city has a code that is 100% clear or objective, or that it's even possible to do that. Next slide, please. Talk briefly here about some constitutional issues. There's a term in constitutional law we call a taking, which is a governmental appropriation of private property. And this is most often you'll see condemnation, where if, say, for example, the state wants to build a new highway, it's going to cross some people's private property. They'll try to negotiate with the private property owners to purchase that property. If they're not able to do so, they can use condemnation, also called eminent domain, to take that property, but they then have to provide just compensation to the property owners. Where this comes up in the context of land use is what we refer to as exactions, which is a condition of approval for a development application that requires the developer to transfer private property. And that can take the form of physical property, such as dedicating land for right-of-way for a road. It can also take the form of economic property, such as requiring them to incur the expense of constructing certain improvements or paying system development charges, for example. Those in order to be lawful, must meet two requirements. They have to have nexus and proportionality, which essentially means there has to be a relationship between what you're requiring the developer to do and the underlying regulation of the property, and that has to be related in nature and extent to the impact of the proposed development. So what that means, for example, what you can require a developer to do as far as how much right-of-way they dedicate for roads and how many road improvements they construct for a 200 lot subdivision is going to be a lot more than what you can require them to do for a 3 lot subdivision. There has to be that proportionality between the impacts of what they're proposing and what you're requiring them to do. And there also has to be some level of connection between those impacts and what you're requiring them to do. So for example, if they are proposing to put in a subdivision, you can't require them to put a new TV up in City Hall for your city council meetings. That wouldn't be related to the impacts of their development. Next slide, please. I believe this is my last topic. Thank you for bearing with me. This is just an update on some really significant recent legislation from 2024. And if you're following the 2025 legislative session, for better or for worse, there will be a lot more in this category to report on probably pretty shortly here. But Senate Bill 1537 was the most impactful from 2024. What this did, among a number of other things, was create a process for mandatory adjustments that went into effect on January 1st. This is essentially variances that cities are required to grant. And cities are required to allow up to 10 adjustments to certain specified land use regulations in applications for development of housing. There are unfortunately a lot of ambiguities in the statute, including such, you would think, simple things as how 10 is counted for purposes of what constitutes 10 adjustments. But there is a very long list in the statute of the types of regulations that cities are required to grant these adjustments or variances to, including such things as side and rear setbacks and minimum lot sizes, parking minimums, etc. Next slide, please. The other thing that this legislation did, effective January 1st of this year, was expand the definition of what we call a limited land use decision, and make that process mandatory. So for a long time now, we've had in Oregon law something called a limited land use decision. And what the law did was it said, these types of decisions are limited land use decisions, and you are allowed, not required, but you're permitted, cities, if you choose to do so, to provide a more streamlined process for making those decisions that does not involve a hearing, unless it's appealed. Legislature did two things. They added more things to the list of types of decisions that qualify. They added replats, property line adjustments, and extensions or alterations and expansions of non-conforming uses, as well as the mandatory adjustments that we just talked about. They didn't add that to this part of the statute, but they clarified that that is also a limited land use decision. And they also made that streamlined process for deciding those mandatory. Cities are now required to use this process that involves no hearing unless the decision is appealed, to make all those categories of decisions, including the ones that were previously part of the definition, which most significantly includes site review and design review. Next slide, please. So I covered most of this here in my discussion on the previous slide. What this means essentially is that cities are going to have to adjust their review processes. The typical type 3 process that involves a hearing for the initial decision will not comply with state law, and cities will have to use either a type 2 process where it's the decision that is initially made by staff, or potentially some type of a hybrid process where the planning commission may still make the decision, but they do it without conducting a hearing. Next slide, please. So this slide, I just listed a couple resources that you can use if you have want to do some further reading. And this is also your last opportunity to ask me any questions before I hand it back over to Emily. All right. Well, thank you, everyone. I'll pass it back to Emily.
Thank you very much.
Thanks, Josh.
Thanks, Josh, appreciate it. Okay, so we have got about 50 more slides to get through, but here's what we're gonna do. We're going to spend time on ethics, but we're gonna move rather quickly through public meetings and public records, because you should be doing your public meeting stuff elsewhere in public records. Not super important for you, except to know that you create them and you can't throw stuff away. So let's do ethics. We're gonna talk about these things here, and now we're gonna move right to the first one. So Oregon has laws that govern the conduct of public officials, and public officials are all those folks in that checklist right there. For you guys, that is the elected official. So anytime I say public official in this training, it pertains to you as elected officials. And here's the caveat part of that. Ethics questions are extremely, extremely fact specific. So it's not possible for me in this context to give you the answer to every scenario you may be faced with as an elected official. So all I'm doing here is flagging the big 5 rules, certain fact patterns to be aware of, and giving you enough information, not to be dangerous, but to know when you need to go get some advice, either from Eileen, from us, what have you. Okay, so rule number 1, don't use your position for financial gain. So under the law, a public official cannot use their position to obtain a financial gain or avoid a financial loss for themselves, for their relatives, which has a definition, for their household, which has a definition, for their businesses, which also has a definition, if, but for, and that but for quotes is important, but for the public official's position, the opportunity to gain or avoid that financial loss, like dead loss or benefit would not have been available. So we have a very comprehensive list of what a relative is for the purpose of this rule, and I will let you read that. I won't read it aloud to you. We also have a very comprehensive list of what a business with which the public official is associated here. Any private business where the public official or their relative, based on the previous definition, is a director, owner, officer, employee, or where the public official or their relative owns more than $1,000 worth of some kind of stock or equity interest. And for publicly held corporations, it's whether that public official or relative is an officer, director, or has the equivalent of $1,000 worth of some sort of interest. So, for example, if a counselor's daughter owns a landscaping business, then that landscaping business is a business with which that counselor is associated. If another counselor inherits $150,000 in Apple stock, that would be really great, and now Apple is also a business with which that counselor is associated. So those are the strictures on who falls within the ambit of not acting within for gain or detriment. But I have some examples in here of how to be more illustrative. Yeah.
Okay, so that's $1,000 worth of stock directly, or that doesn't count for within mutual funds or retirement plans, things like that, or?
I don't know. That's as specific as the definition gets, but I can look into that.
I mean, do we have to start watching our portfolios to make sure that we don't get anything? I don't know.
That could be difficult.
Oh.
But let me look into that and I'll get back to you.
Okay, sorry.
That's okay. So say for example, the mayor, not this particular mayor, but the mayor of a city signs a contract that obligates the city to pay for janitorial services from a business owned by the mayor's son. So that would be the mayor using their authority, their position as a public official to obtain a financial gain, because but for their position as a public official, they would not have been able to obligate the city in that contract, and their son would not be getting the proceeds of that contract from the city. Any questions about financial gain stuff?
Yeah, question.
Yeah.
Would it be the best practices to not do business with anybody who's a city, who works for the city, or, I don't know, I'm just curious, because I do business with all kinds of people.
Yeah,
And city business almost never comes up.
when you're doing business, are you acting in your capacity as a counselor?
No, I mean, I do tax returns, do accounting, financial planning, business, that sort of thing, but
So
obviously.
you're not necessarily getting that business because of your position as a counselor, but
I
if
don't
you,
think so.
if you sat up here.
But if the guy came to me and said, hey, I saw you at the city council, I thought I wanted to use taxes, I mean, I don't know, I'd say yes or no, should I say no?
I don't think the law requires you to do that, but if you switch the facts a little bit, and if you're up here like actively soliciting business, like at the close of every council meeting, you said, by the way, call me for tax help, that would not be okay
I'm
under
too
the
busy
law.
now, don't come to that.
Yeah, you sound like you don't need to drum up business right now. But good question, certainly something to be aware of. Let's see here. Okay, so the second rule is that you are not allowed to receive more than $50 in gifts per year per interested giver. And of course, we have a lot of definitions in this as well. So the law says that a public official cannot receive, solicit, either directly or indirectly, any gifts individually or cumulatively, so more than $5, $10 gifts or a $60 gift, for example, that exceed those $50 from any single source. So that $50 is limited source to source. If that source could reasonably be known to have a legislative or administrative interest in the public official's actions. And for you as elected public officials, that means decisions, votes that are before you as members of council. So here, gifts are anything that has economic value, that is given to the public official or the public official's relative or member of household. And here, member of household means anyone that resides in the same house as a public official. That is given without receiving value back, so you're not paying for it, you're not bartering for it, you're not exchanging services for goods or anything like that. It is not given to the general public on the same terms. So someone who is not in the same public official position would not have the opportunity to gain the benefit of this.
So I have a
Yes.
quick question. Here's a classic one that we kind of run into from time to time. Many of us go to the Chamber of Commerce luncheons, and you can buy raffle tickets for prizes at the luncheon. And if you win said prize, did you technically pay for that because you bought the raffle ticket, or is it considered a gift?
That is literally my example I was about to read for you.
Oh my gosh, look at that!
You are, have you seen my notes?
I
Yeah.
want
I need to buy a lottery
$25
ticket,
gift
but
certificate.
not, I shouldn't have said that because now I'm gonna have to declare it.
So, you bought a raffle ticket, and you won a TV, is that what your example was?
No, like a basket of chocolates.
A basket of chocolates. So if you paid less for the raffle ticket than the value of the chocolates, then you have received something without receiving value back. So it could be, a gift could be something you don't pay for entirely or you receive a discount. But that doesn't necessarily make this a gift for the purposes of $50. You also have to look at whether it was given to you as a counselor under terms that's not available to the general public. So if the general public could attend this gathering meeting that in your hypothetical, then they would have the opportunity to buy that raffle ticket as well. So there's nothing special about you here.
Okay.
But then we also have to look at, is the person who's giving the gift, so offer the raffle ticket and then is giving you the prize in exchange for being the lucky guy with the right raffle ticket, is that someone who has a legislative or administrative interest in a decision that could be before you as a member of council? So and which I'll get to in a second, but there's layers here. But at any of those factors, the answer is no. Then it's not a gift for the purposes of those $50 counting per source. And legislative or administrative interest. Here we are. So this looks into whether the source of the gift, so the person who's ultimately giving the gift, has some sort of economic interest in an action or a decision that is properly before you as a counselor that is distinct from the general public. So the general public always has a legislative interest in, the council doing its job properly. So that doesn't count. But for example, if there was a contractor who put in a bid for an RFP for a contract with a value above $50,000, so a contract that council would have to approve via 2 ordinances under your charter, and they are giving you a gift, that is certainly someone who has a legislative interest in your actions. Does that make sense? And so in your particular example, I'm not sure if that person would have a legislative or administrative interest in your actions, but yeah, as Josh said, anyone who has, for example, an application before the city for some sort of development is going to always be someone who has an interest for the purposes of gifts here. Any questions on that part? Okay. The law specifically excludes this list of things from the definitions of gifts. So campaign contributions, that's something that you each do as a person who is running for an elected office. Those aren't gifts. I'll scroll down, the very last one, food, beverage, and entertainment when acting in an official capacity representing the city. So if you are council's delegate to some sort of convention and the convention is feeding you while you're there, that's okay. Incidental food, beverage, and entertainment, it's, one of my old bosses used to call this the cheap buffet food exclusion, where if the purpose of you being somewhere is not to receive food, beverage, and entertainment, then your receipt of those things is not considered a gift under the law. Any questions on gift exclusions?
We can't do a gift exchange for Christmas.
I think you probably could, especially if you put a dollar limit on it, like a white elephant of $10 or less.
$24.99.
Let's see. Yeah, okay, so that's gonna take us to our next rule. I guess I'll pause there for any other questions about gifts. Okay. So conflicts of interest, Josh already touched on this a little bit. There are 2 types of conflicts of interest. There are actual conflicts of interest, and that definition is right there on the slide before you. An actual conflict of interest is an action or a decision or a recommendation by a public official that is certain to have a private financial benefit or detriment to that public official or relative under that same definition of relative, or business associated with the public official or the public official's relative under that same definition of business associated we already talked about. So actual is something that will have that private benefit or detriment. Potential is something, any decision, any action, decision, or recommendation that is not certain to, but there exists a world in which that action, decision, recommendation could have a private financial benefit or detriment to the public official and those same folks. So actual, would, potential, could. And the distinction is important because what you have to do as public officials is different for each. So for
So a
both,
question about that.
Yeah.
So I have a business that is located in downtown Canton. Pretty much if they said, oh, we want to charge for parking for downtown Canton, that will have, I'm just hypothetical, would have an effect on my business. Every else's business, but my business as well. Same thing if they wanted to tear up this Grand Street, that would affect my business. Or those kind of things I need to recruit myself on because these are things that affect Canby itself, but
Right.
because I have a business in Canby, they affect me.
That's a good question. So you're asking about something that OGEC, or Government Ethics Commission, calls class exemptions to the conflicts rule. And what that means is, we're gonna move forward. Yeah, okay, 2 slides. So exceptions, it's not a conflict of interest if the financial benefit happens because membership in a class as determined by OGEC. So what this means is that OGEC, and only OGEC, has the authority to say, this certain distinct group of people, if a public official is in this group of people and the public official's decision would impact this group of people, we're not gonna call that a conflict because the public official being part of this distinct group of people won't be impacted any more or less than the other members in this group. So this doesn't come up very much because it is something that OGEC tightly controls. They are the only ones that could designate a class that would be exempt from the conflicts of interest rule. But say, for example, you have the board of a public university, and the board has like 25 members on it, and one of the board members is actually a student actively enrolled in the same public university. Before the board is a decision as to whether to raise tuition rates. So as a student, that board member is going to be impacted by the board's decision one way or the other. However, that board member as a student is in a class of, I don't know how big, like U of O or what, of 50,000 other students or something like that. In that case, OGEC may decide that because of the number of individuals in that class, how they all will be affected the same way if the board decides to increase or not tuition, that this particular board member does not have a conflict of interest and can participate in that vote. Does that make sense? And OGEC takes into account certain things like the number of individuals in the class, how dispersed the effects of a decision would be to the other individuals in the class versus the public official in question. So in your particular example, I think it would depend on the number of businesses who would be impacted, the nature of the businesses. Maybe some are drive-through businesses where they wouldn't have people parking, so the pay to park wouldn't have, an issue. But maybe for yours, your customers do need to park, and so pay for parking may impact foot traffic or something like that.
As an example, there may come up shortly a thing to raise the business license fee.
Mm-hmm.
Right, and so obviously I would pay more if that were raised.
Yeah.
And so obviously it directly affects me, but I can still make a decision, or do I need to recuse myself from that decision? Because obviously whatever decision is made, I can say, hey, I don't want to pay that fee, so I'll vote no. Or the city should make it, vote yes, but I think it's something I can, so it directly affects me.
You're right.
And the same thing for if they wanted to start charging for parking right next to my office.
So that is coming down the pipe for you, like that is actually gonna be a decision in front of council at some point. I recommend reaching out to OGEC to get their guidance, because they are able to issue explanations, advisory letters, and that sort of thing to public officials based on real situations that the public officials face. And ultimately, they're arbiters of whether someone violated the law or not, so having their approval, I don't know if they would be comfortable with me saying approval in this sense, but having their approval on a situation, or their read on the situation is the most important thing, because they're the ones who are gonna come down on it.
But imagine that happens a lot, even if I raise a street fee, every tax that we impose is on myself.
Yeah.
So.
Yeah, it's a good point. I'm gonna back up. Okay, here we are. So when faced with a conflict of interest, whether it's actual or potential, the first thing you do is on the record, state the nature of the conflict. Do this right away, do it before any voting or discussing of the matter takes place, and then do it at each meeting at which the matter is discussed. And again, do it right away before any discussion or voting takes place. That's for both actual and potential. For actuals, after you declare it, then you're done. You can't take part in any discussion. You cannot vote on it. And our recommendation is in the interest of, public perspective, to physically remove yourself from the discussion taking place too, just so it's very clear that this is a line, I have a conflict, I'm not part of this. And of course, you have to do this at every single meeting in which the matter is discussed. There is a single exception. If the otherwise conflicted out public official's vote is needed to meet minimum requirements for quorum, you are allowed to take part in the vote. You may not take part in the discussion. And if this ever becomes an issue, my advice is to consider whether postponing the vote and discussion on that particular matter is possible.
Well, but, so like, if the problem is not number of votes, but number of voters, so the quorum problem is if this person says, I'm outing because I have a conflict,
Then you don't
now
reach
you
a
lose quorum,
Yeah,
bam.
If
Or if they are here, if they're like, I'm not gonna participate in this, but I'm going to remain here at the seat and let you folks do your thing, so quorum may stand, but they don't participate in the vote, like, is that the thing?
Well, they'd have to participate, they would just be an abstention, right? It would be
Are
on the record as an
abstentions-
abstention.
permitted, other than in the case of conflict under your charter? Okay. Then maybe, let me look at that, all of your charter language on abstentions there too.
Okay.
Down.
If anything about liquor license and having abstain, that would be such agenda. That was the personal choice, and that was right. There was no conflict.
Okay. Okay, so the other, we already talked about class, membership in classes as an exception to the conflict rule. Also memberships in a nonprofit is a conflict as well. An exception to the conflict rule as well. Okay, any questions on conflicts before we move to 4? Great. Number 4, no nepotism, please. So, under the law, a public official for their relatives or members of their households cannot appoint, employ, promote, discharge, fire, demote, or participate in any interview, discussion, or debate regarding the same for their relatives or household members. The law also says that a public official may not supervise any of their relatives or members of households. The law doesn't say that a city can't employ relatives, more than a person who is also related to another person who's employed or a public official at that city. It just draws lines between their interactions. The exception here is unpaid volunteers don't count, so a public official could supervise a member of their household or relative if that person was just a volunteer for the city. And then the law does allow cities to exempt by policy, or to exempt by policy this rule. So if city policy allows, then a public official could supervise a relative. I'm not sure that's the case for your city's policy. I would advise against it just as a best practice right there.
What about an advisory board member? Are they considered a volunteer? So.
It might be a public official.
One of my kids wants to be on the advisory board, there's a lot of openings.
Well, are you supervising them?
No, I.
Do you appoint to advisory boards?
We, as a council, we appoint to advisory boards.
Okay, then that may be an issue. If we go back to our definition of public official. Oh, I went right. Yep, there it is. An appointed official. So if you're appointing members to an advisory board as an official act, then that could be an appointed official. So in your particular case, if in your hypothetical, the safest thing to do would to not take part in the official council action that would appoint that person.
It's like, that's why when council says to abstain from the budget vote, because it's not a work here. So there's provisions for that.
That also goes towards financial benefit rule as well, because voting on your relative's wage is also a financial benefit to your relative. Okay, last rule here, don't use the confidential information you receive as a public official to further some personal gain. No insider trading rule. Any questions on what that means? Okay. So what happens if there's a violation? So OGEC is the state agency that oversees and has authority to investigate, find violations, and impose penalties for violations. So there's a penalty amount, it's $5,000 maximum. In addition, OGEC could order forfeiture of any financial benefit realized from the ethics violation, 2x that amount. They also have the authority to issue letters of reprimand, explanation, or education. The important thing here to remember is that any sanctions are personal to the public official, because violations are personal to the public official. The resulting sanctions are personal as well, which means that the city cannot pay that up to $5,000 civil penalty, it cannot pay whatever forfeiture amount is required, etc. That being said, decisions that are made as a result of some sort of ethics violation, so someone voted when they had an actual conflict of interest without having that exception available to them, that's not necessarily voided, that decision. Any questions there?
Just as a curiosity question more than anything else, city can't pay the fines or anything like that, right? But as far as any kind of process for the OGEC, what is the city allowed to represent or to be a part of it, or is that just me on my own, show up by myself?
On your own.
Okay.
Yeah, the only way that the city might be involved is if OGEC asks for certain information from the city. But the city wouldn't be involved on the part of, in defense of, or representative of the public official who is accused. We already talked about what OGEC is. Okay, a couple of hypos here. I'm happy to read these aloud, but you all can read yourselves. I will give you 15 seconds, and then I'm gonna move on to your potential answers. Okay, what do we think? Why is it no good?
The mayor's putting his own.
Sign his own checks.
Yeah.
Bad accounting. Never have to issue everything signed.
Number 2 is the answer.
Yeah, it's number 2. So in this case, there is a financial benefit to be had on the part of the mayor.
You can't sign no check.
And the mayor, but for the mayor's position as the mayor would not have realized that financial benefit. So yeah, that was a problem. That was an ethics violation right there. And it was a very well-meaning one. I mean, the point of signing their own check was to expedite process. But even the best intentions can get you into trouble. Okay, another hypo. Give you 15 seconds on the clock. Okay, moving to potential answers.
Number 3.
I say 3.
Say 3.
Is that what we all think? Any brave dissenters?
Don't know the value of the gift.
So, we're saying 3, no, the meal is incidental to the convention. Let's go back to the facts really fast. City councilor is invited to a large luncheon put on by a software company during a national conference. So it's not the conference putting on the luncheon.
Number 4
Oh,
then.
it's tricky.
Yeah, I know,
Number
right?
4. I don't know. Value of the meal.
Well, if that's the case.
I guess,
Yeah.
number 2.
2, we think 2?
2 or 4, I don't know.
Part of the national.
I would just call Emily and say, can I have this lunch?
And I would say, how much is that lunch worth? Because if it's over 50, it's a gift that you can't accept because,
Okay, number 2.
yeah,
So is the food good?
Yeah, exactly. Is it, I mentioned my old boss, the thing that, how should we describe this was, is it like a pizza party from Domino's, or are they doing like surf and turf, lobster and fillets or something?
Vote.
I'm pretty sure when the LSC puts on its conference, it tells you how much the buffet is worth, or it tells you how much the meal is worth. So this is a hard one to keep track of because it's not like ordering off a menu, but this software company is an interested party because it sells the software that the city is in the process of soliciting, and this particular counselor will have a vote as to whether to award it to this software company or to someone else. That might go towards Josh's explanation of criteria upon which you must
You gotta
make a
take,
decision.
when you get the buffet, you gotta take a picture of your plate so that you can say, I only have $25 worth of food on my plate. Don't go up for seconds.
Yes, always be careful of seconds. Okay, so Hypo 3, conflicts of interest. I will let you read that for a minute. Not a minute, but. Okay, here we go. So we're clearly dealing with a conflicts of interest issue here. The first question is, what kind of conflict is this? Is this an actual that would certainly result in a private financial benefit or detriment, or is it a potential that could have that effect? And I'll flip back to the facts real fast so you can think about that.
In the,
Commissioner has an issue for sure, I would say the
Counselor, yeah.
Oh, if it's a,
Right.
if this is a citywide thing, it's the broader
Yeah.
version, it's not like.
because
You're
it's
not-
citywide thing, everybody's property, unless it's affected
planning commissioner
by the zone. You can't say a citywide zoning is, and then the whole council is disqualified, and then we can't vote, right? If you're doing it that way. If you're-
Well, let
that's
me
not-
tell you this, so we don't know what kind of impact the rezone will have on property values, right? So that's where the financial interest is, or most likely is to be used in property values. So the rezone could result in an increase, it could result in a decrease, it could have no impact whatsoever, we don't know. So we don't know if there will be a benefit financially or detriment. So this puts us in the realm of a potential conflict. But your point about it being a citywide legislative decision is a good one, which is why I'll run this by Josh. I'd be curious to hear his land use perspective. But in this case, I see this as both the planning commissioner and the counselor having a potential conflict of interest. And the safest thing to do would be to mention it on the record every time it came up. But remember that a potential conflict just means you have to bring it up. You can still have the discussion and you can still vote on it.
So, just out of curiosity, Canada's a fairly small town. Could you have a conflict of interest where pretty much everybody in the council is disqualified? I mean,
It's hypothetically possible,
I mean,
but remember, you have that exception to actual conflicts that say that if that particular counselor, or in this case, every single counselor's vote is needed in order to reach a quorum.
Well, and I think in this scenario too, it would be different, like, as a city councilor own a, 10,000 square foot lot. Whereas, and so the impact that it might have on my lot proportionally would be different is if I was a city councilor who owned 7 or 10 acres of land within the city that is ripe for development, right? Like, I'm not gonna squeeze housing development on my 10,000 square foot lot unless it's like Berry Village.
And that's something that the OGC could consider when deciding whether to grant a class exemption or not to conflicts issues. So there's no clean answer to this one, but it really does highlight how we gotta be thinking about these things and all the different factors that could come into play. I'm gonna move on to do some brief public meetings and records, if that works. Okay. So Oregon has a public meetings law that generally states that all public meetings have to, with certain special exemptions, have to be held openly and so that the public can attend if they want to attend. And this law came about in the 1970s. It was very much a reaction to Watergate type activities where government officials were doing suspicious deals in dark and smoky rooms in the back of City Hall and that sort of thing. So that's the intent behind our public meetings law. And what that means is that every governing body is a public body. So city councils, county board of commissioners, planning commissions, subdivisions of city councils, citizen groups formed to advise, specifically advise the public body, those are all governing bodies subject to this law. There are certain procedural requirements for holding public meetings, including advance notice. They have to be held within certain locations. More recently, and particularly for us, they have to be held in a way that the public can access them remotely, either telephonically or via Zoom or Teams or something like that. And if there's a situation where the public has a right to provide comment, they also have to allow the public to provide comment remotely, telephonically as well. One of the big rules is that voting has to be open. There can be no secret ballots. Everything is tallied and attributed to each member of the governing body, and that minutes need to be kept of every single public meeting, including executive session. Certain items of public meetings have to be committed to the minutes, though minutes don't have to be a verbatim recording of the public meeting. And that's something for staff to keep track of, but just so you're all aware of that requirement. Except as otherwise required by law, the public has a right to attend, but doesn't necessarily have a right to provide comment or give testimony at public meetings. It is well within your authority as council to designate time and to allow public comments, but it is also within your right in council to put time constraints, to put decorum standards and topic constraints on public comment periods. And you also have the authority as council to remove someone who is not complying with those laws. Though that can be perhaps a risky thing to do, which is why we strongly suggest having very clear and comprehensive rules to govern public comment periods. So all meetings of the public body must be open to the public and the public must be allowed to attend. You can't have a quorum meet in private. And the meeting here is the convening of a governing body, of a public body, for which a quorum is required to make a decision or deliberate towards a decision. And convening, a quorum here is the minimum number of members that must participate in order to transact business. Quorum isn't a state law defined thing, it defers to local law, and if local law is silent, then the default is the majority of the governing body. So your charter says the majority of council, and council is 6 councilors, so the majority would be 4 councilors. And the non-voting except in the tie, so then the tie mayor doesn't count towards quorum in that regard. Meetings can be convened in multiple different ways, as you're all aware, so gathering all together physically, like we're doing now, gathering together via the power of the internet or the phone is also a meeting. Serial communications, we've talked a lot about this, how it's possible to convene a meeting just by emailing a number of, the number of councilors required to meet a quorum, that's technically a public meeting. And then using an intermediary to communicate, so having one person serve as a messenger between at least a quorum of members is also a public meeting.
I have a question about that.
Yeah.
So, before I was a city councilor, sometimes, not often, but sometimes I wanted to talk to city council, and I had on an issue, that was one issue, and I meet with several of them on the one issue. Did I create a meeting by saying, I want to lobby or whatever the city council individually?
No, not necessarily, unless you, like if you met with councilors A through D, each individually, and got their perspective on something or communicated a message to them, and you did not go back between counselors A through D to carry messages to all of them on their behalf. So you weren't doing the equivalent of,
Well, I mean, I might say, I talked to, you know, Councilor Hensley, and she said this when I was talking to Councilor Patton, and then if I talk to Councilor Davis, I'm talking hypothetically, and I'm not a member of the city council. But I'm just wondering how, because that seems almost like it's, I don't know, it's like a court case that might be fun to challenge, because it seems like it interferes with the right for.
from what you're describing, it doesn't sound like the counselors are deliberating or making a
Yeah.
decision.
I'm just, but obviously I'm not careful.
They're just relating viewpoints.
Yeah, I'm not careful of saying, you know, well, yeah, man, Hensley thinks this, and I go to Waterman, and then I go back and they say, well, Waterman said this, you know, but I'm not even on the council, I don't know about these rules, you know. I can just see it happening, because I've actually, I think I've seen similar things happen to me, where people come to me and say, some other counselor said this or that, you know. And I'm just like, okay, but it's a citizen, you know. Which I think has a right to go talk to city council.
I don't think there would be any violations of the law based on what you described. I think we're missing that deliberation or decision element.
I was just curious, like, because of the other thing, like.
Yeah, I mean, in these days, how things get changed, it is a bit of a moving target, but I think you'd be just fine.
So real quick, the
Yes.
version that you emailed us, just a second. I'm just letting you know that the version you sent us via email is missing that quorum slide.
Yeah, I adjusted slides around 4 p.m. today.
Oh, okay.
And you'll see that there is another change slide in a couple of slides from now.
Okay, 'cause
Yeah.
I was like, what am I doing? I missed something there.
But my will you send out the, yeah, great.
So, question,
Yes,
does this extend to our boards and committees as well?
it does. Yep, they are all subject to this law.
So they can't be, just like us, we can't have a group text about something, or text so-and-so and call so-and-so, and
That's
if
exactly
they
right.
have a quorum, they can't.
Yep, that's exactly right.
So in terms of
Good
like
thing that they're in that case
posting,
then.
like, I mean, quorum notices, or not quorum notices, but meeting notices for committees and boards, they need to follow the same pieces as we do.
They do. Yep, they're subject to all the agenda, notice, meeting space guidelines. These are things that are not meetings. I would say that under the social gatherings bullet point, it is very easy for social gatherings to slip into discussions of matters that could be before council. So be very, very cautious when convening a forum just to talk socially. And of course, serial meetings are always a risk, but if you are sending out an email just to check on scheduling or to propose a new meeting time or something like that, that would technically be fine under the law, except always be careful of the slippery slope that conversation could move beyond purely factual or educational nature and into something that would trigger a public meeting. So best advice is to don't do that. And Eileen is here to facilitate communications about scheduling stuff, for example. Executive sessions are public meetings, but they're a public meeting where you can exclude certain members of the public. They're very limited under policy to just the list that's listed in that statute right there. Executive sessions aren't a requirement. Anything you can do in an executive session, you are 100% able to do in open session. So it's really a choice there. As we talked about before, you have to announce the statutory reason for going into executive session on record in open session before you do so. You guys are really good about that. No final actions or decisions in executive session. We've talked about that a lot. Press, this is one that always is a little difficult to navigate sometimes. So press can attend almost every single executive session. There are 2 executive sessions that they cannot attend. One of them has nothing to do with cities, and the other one is executive sessions held with individuals designated as labor negotiators on the behalf of the city. So the executive session we had last week was one that we could exclude members of the news media from.
I have a quick question on that.
Yes.
In terms of the news media, with everyone thinking that they report the news now, what what is a news media now? Do they have to have credentials or is it anybody that can be involved?
Good question. You're right, so there are so many blurred lines these days. Someone can have a blog with 5 viewers on it and then call themselves a representative of the news media. The law does not give us an answer, and it's something that governing bodies grapple with all the time. General consensus advice is that if this is a person who is employed by or an agent of an established, recognized news entity, so one of your big TV stations or a newspaper, whether local or not, then that is someone who is a member of the news media. If someone does this as their job and they get paid for it, that is a member of news media, probably, but then it's possible to monetize blogs, for example, through ad revenue. So there are certain factors that we consider when making the determination one way or the other, and if it ever pops up for the city, please reach out and we can walk you through that analysis. But yeah, it's certainly an area of the law that could use quite a lot of clarification.
How much litigation is actually involved in this stuff? Because so much of this is unclear. You would think that somebody would have challenged it and clarified the law. But I'm just curious, is there a lot of litigation, or is it basically usually what the ethics commission says stands? And
Yeah.
I'm just curious about that.
So there's a process for resolving complaints that actually is rather new this year that's sort of designed to resolve these things at a lower level. So I don't know how much actual circuit court and of litigation arises from these things. Obviously, we have that Lynn County serial meeting case that made it, I think, at least to the Court of Appeals. I think the decision came from the Court of Appeals. But by and large, I think the complaint and the grievance process that has to come first now under the new law handles a lot of this. Also, our general advice is to err on the side of caution when determining whether to admit someone as a member of the news media or not. So you err on the side of over admitting rather than under, which eliminates the risk of having decisions challenged potentially up into court. Is that a satisfactory non-answer to your question?
Yeah, it's not an answer, but I just.
Yeah, sorry.
I've always, if it's no good law, there was make it or something, but that's
Yeah.
maybe not. Side has one on.
Along that news media thing, is there a way for the city to develop a policy that if you want to claim that you're a member of the news media, you have to fill out some sort of vetting application, and then you have to get credentials from the city, like a press pass
Right.
through the city, and that process, they have to list like what their thing is, so that we have that on record, and then they essentially are designated as someone from the press that's been approved.
I don't believe the issuing a press pass or the equivalent designation is something that a city can do under the law. I double check that, but I looked into this a couple years back, and I don't believe that's something you can do. You can certainly ask questions. You can say, hey, who are you employed by? Who are you reporting for? What's your reporting medium? That sort of thing. But going so far as to issue a press pass, I don't think that that's okay, but I'll look into it and follow it up.
So if somebody walked in the room and said, I want to be in your executive session, I'm a media person, I mean, what do? You just say?
This has happened before. My advice is to postpone the executive session until we can figure out who this guy is.
Okay.
What the merits to their claim of being a member of the news media or not. Which is, of course, not a very clean and not a very efficient way of handling these issues, but the law doesn't give us much recourse in these situations. For example, when you read your script and you say any members of the news media in attendance are directed not to report on the matters discussed within, you can certainly direct them not to, then they can go and report on it, and it's not like they will be subject to any penalties. You can't take any actions against them. For example, you can't exclude them from future executive sessions just because they disobey the directive. So it's really kind of a toothless thing here. A couple of typos that we can and I'm happy to skip through these in the interest of time, I'm seeing a lot of blinking eyes up there. Thumbs up or down for fast forwarding?
Fast forward.
Fast forward,
If you want
cool.
me, I can talk about everything.
Okay, public records. So the important things for you all to know here is that Oregon law gives individuals the right to inspect public records that are not exempt from disclosure based on a specific list of, or to a specific list of exemptions in the law. So any writing that you make, any text message, any email, any social media post, any jotted down handwritten notes, any Word files, anything that you create in the course of your duties and within your scope as counselors is a writing subject to the public records law, and it must be preserved as such, and it is subject to disclosure as such. So that's why we strongly recommend not using personal email addresses for things. Y'all are really good about using your city ones. Using personal phones to text is always dangerous. Social media, private messages on Facebook or Instagram or whatever, those can all very well be public records subject to disclosure. So that is, you should really keep an eye on how many public records you're creating as public officials, because there's no duty to create a public record. You're not obligated to create public records, but once you do create them, then they are subject to the rules. I think that's all you need to know there.
So when I hit delete on my emails, spam and junk, it's not.
No.
Always everything's on the city server. Yeah. You can delete out of your inbox, but it's.
Which is good, which it should be, so that in the event that that piece of spam is responsive to a public records request, then we have it to disclose. What do we think about this one?
Yes.
Yes, it's a public record.
Yay, good
Even though they're
job.
talking about soccer, that's not how it started.
No, but it's how it ended up, which is the same thing for meetings, slippery slope. That's all I have. You have been abundantly patient with this very long presentation, and I thank you very much for that. I have a few follow-up things to look into that I will get you answers to. Any questions right now, or we shall end this and move on to the night?
Any questions? I think we're good, and we thank you very much for
Great.
taking us through that. And, I will conclude our work session. We will convene, city council / exec meeting here after a 6-minute break. So 8:45, please be back.
Bye.
Bye.
Have a good night.
I think we're gonna do it right.